Hi, I'm Jason Sullivan of Rathbone Group, and this is On Subrogation, your free video resource to assist in your subrogation claims. In this video, we're going to take a high overview look of the litigation process. You may be a claims adjuster and send files out to an attorney to pursue your subrogation claim. They may give you statuses and updates, but you really don't know what's going on with the court and its procedure. You're not sure how long you can expect the case to go on or exactly where you're at in the process when you get those updates. This again is a high-level overview. We have multiple other videos and podcasts, the On Subrogation podcast, that cover a lot of these details in more depth and provide a lot more information to help understand exactly how these civil procedure things work. First off, a lawsuit is started when a complaint is filed in most states. That initiates the entire process by filing the complaint with the court. Each state has their own rules about how much detail must be included in the complaint. After the complaint is filed, it needs to be served. There are some exceptions, and we have some great podcasts on all the different service rules, but you serve the defendant and put them on notice that the complaint has been filed and you're making the claim and asking the court to decide the issue. After service, the defendant has a certain amount of time to file an answer. It varies in the states, but it's usually between 3 weeks and 6 weeks that a defendant has to appear before the court or file an answer and say what they dispute or what they admit regarding the complaint and the allegations. If a defendant fails to file an answer or an appear, it's possible the court will enter a default judgment. That merely is a statement or judgment issued by the court that says, everything the plaintiff said we're going to take as true because the defendant did not come forward and dispute it, and therefore we're granting the relief the plaintiff is seeking in that case. Assuming that the defendant does file an answer, either on their own or with an attorney, the case will then proceed through litigation. First, there'll be the pleading stage. The complaint is a pleading, the answer is considered a pleading, and any other cross-claims or counterclaims may also be filed at that time and are part of the pleading. We have videos and podcasts on all of these issues regarding counterclaims and cross-claims if you have any questions or want to know more about those things. After the pleadings are closed, the parties usually then go through a discovery process. Discovery is the mechanism by which parties can find out more about their case and the strength or weaknesses of the other party's case. You get information through this discovery process. The main tools are interrogatories, which are written requests for information that the defendant then responds to. The defendant may also send them to the plaintiff, and the plaintiff must also respond. Depositions, that's taking sworn testimony of a witness or a party to the case. It's usually taken before a court reporter. It may be done by video, and it's an opportunity for an attorney to ask that witness or party questions on the record. They give their sworn answer, and it's all documented in a transcript that can later be used in court if necessary to either impeach the witness or to put forward that evidence if the witness is not available. We have a lot more detail on those in our evidentiary videos that are also on YouTube. Admissions are a third discovery tool, and that's a party's opportunity to send to the other party, the opposing party, a list of statements or questions in which the other party either has to admit or deny. It is a great way and tool to narrow down the issues that are actually going to be in dispute before the court if it does go to trial. A lot of courts have, as part of their civil litigation process, a requirement that parties go through alternative dispute resolution. That may either be a form of mediation, where the parties try and work out their differences, and there's a third-party mediator who tries to facilitate and find some compromise or common ground to resolve the claim. Or an arbitration, which is more like an informal trial. The rules of evidence usually are not as strict, but the parties put forth their case and a neutral arbitrator will make a decision. That can be binding or not binding. The court may require these, and so parties may, even though they're not members of arbitration or they're not deciding to mediate the case themselves, may be ordered to do so by the court. It may come with additional costs, or it may be part of a court program in which there are no additional fees. It just depends on the jurisdiction that you're in. If the parties aren't able to resolve their claims, they may file motions asking the court to rule on certain issues. One of the first motions I already mentioned is a motion for default judgment, and that's where the plaintiff asks the court to enter judgment because the defendant did not appear or answer the complaint. A motion for summary judgment is a motion before the court that says there are no disputed facts on this issue and the court should just enter judgment as a matter of law. This could be filed by the plaintiff or by the defendant. In subrogation cases, this is not as common because there's usually a factual dispute as to who caused the motor vehicle collision or what facts led to the loss that the insurance company paid out. However, there may be instances where summary judgment is appropriate. A motion to dismiss is frequently filed when there's a procedural issue. The case is filed in the wrong court. The statute of limitations has expired. Any type of issue like that, a defendant will frequently file a motion to dismiss in order to get the case dismissed so it's not even heard on its merits, but it's just out of the jurisdiction of the court. A final motion that may be used, and this is in advance of trial, is a motion in limine. This is a motion before the court to ask it to exclude certain evidence or witnesses from testifying at trial. This takes us to the trial stage. Before we get there, the parties will have made an option as to whether or not to request a jury trial. Each state has different rules on when this must be made and how it is made, but essentially either the defendant or the plaintiff can request that a jury hear the case as opposed to just the judge. If the parties waive their right to a jury trial, then a judge or a magistrate will hear the case and decide both the law and the facts. Juries can be of varying sizes, anywhere from 6 to 12 juries. And after hearing the case, states have different rules on whether it requires a unanimous verdict from that jury, or in some cases, about a third of the states allow a majority of the jury to rule and make the verdict, depending upon the type of claim and the dollar amount that's involved with that. You'll always want to consider for your case whether or not a jury trial, having members of the community decide the facts and the law, is something you would rather have, or if it's a matter that would be beneficial for a judge, or maybe it's just easier for a judge to make those decisions and rule on your case. After the jury hears the case, they'll render their verdict. If the verdict's for the defendant, finding that either there was no liability on the defendant, or even if there was liability, there are no damages that can be awarded, the case is over. If the award is for the plaintiff, it will set forth the amount of money that's owed to the plaintiff. Each state then has an appeals process where parties can ask another court to look over what happened in the lower court. Most of the time, these appeals regard issues that were raised in lower court, whether certain evidence was allowed in, or whether or not the court made a big error on a particular issue on the law, or whether a decision was just arbitrary and capricious. You're asking the upper court to file that. A lot of times you have 30 days from the date of the judgment or the date the judgment is entered to file that appeal, and if you don't file it, that claim is waived. There is one opportunity, though, and that's a motion to vacate judgment. And we see this on uninsured subrogation auto cases, not frequently, but it does happen. A lot of states have a rule that allows a party against whom judgment was entered to have that judgment vacated. It can be vacated because new evidence was found, or maybe there was a mistake that was made and it's considered excusable neglect, or maybe there was an underlying issue with how the litigation proceeded, like the defendant was never served with the summons and complaint. We talked about that at the beginning of the video. If there's no service, they're going to argue that the court didn't have jurisdiction over them and therefore the judgment should be vacated. Many states have timelines in which these must be filed, whether it be 60 days, 1 year, or within a reasonable time, which leaves a lot of gray area to be decided. Assuming that you do get a judgment on your case and that there is no motion to vacate and there was no appeal filed, now you've completed the litigation process and now you move on to collecting the judgment. If you have questions on that, we have a great video on post-judgment executions, especially in the auto context where certain states may suspend a driver's license for not paying a judgment. For On Subrogation, I'm Jason Sullivan, and that's the long and short of it.